Judge Louis Lyman has issued a brand new ruling, and it is going to reshape the entire legal battle that has been unfolding around actress Blake Lively, her husband Ryan Reynolds, their company Van Zandt, and the former Baldoni publicist Stephanie Jones. This development is huge because it changes the direction of the case, and it shines a very bright light on some allegations that many thought might get tossed aside, but instead they survived, and they could be the ones that create the greatest risk. So why does this matter so much? Judge Lyman has just ruled on the counterclaims that Jen Abel filed against Stephanie Jones. Now, while the judge did dismiss several of the federal hacking claims, two of the most serious allegations survived dismissal. And these are the ones that go right to the heart of the story. And that story is, how did Jen Abel private phone data wind up in the hands of Blake Lively and her team? How was that data accessed without her authorization? How was she then cut off from her own accounts? And finally, how did that same data flow to Van Zandt only to show up in a lawsuit filed against Justin Baldoni and Jen Abel by Blake Lively? That chain of events is critical, and what Judge Lyman preserved today is what gives Abel the power to push forward a discovery and potentially trial. We are going to walk through exactly what this ruling means, what Jen Abel won, what Stephanie Jones is now facing, and how this might ripple outward to Blake Lively, Ryan Reynolds, and their company Van Zandt. Let us start with what Jen Abel walked away with in this ruling. On the surface, Judge Lyman did dismiss several of her federal law claims. These included the Computer Fraud and Abuse Act, the Stored Communications Act, and the Wiretap Act. The reason they were dismissed is not because they were necessarily without merit, but because the judge said the pleadings were not technically sufficient. However, and this is the important part, he gave her the chance to amend those claims, which means she can file a stronger complaint with more specific details. So those are not dead, they can come back. But here's where it gets really significant. Two claims survive entirely intact, and they are very powerful. The first is under California Penal Code Section 502, which is California's computer crime statute. The second is conversion, which is basically a civil theft claim. So what exactly does Penal Code 502 say? This California law makes it unlawful to knowingly and without permission access someone else's data. What makes it tough for a defendant is that the statute does not require that the data be sensitive or confidential or even business related. It only requires that the access was knowing and unauthorized. So even if you open someone's iCloud or phone account without their permission, you are in violation. And that is exactly what Abel alleges Stephanie Jones did. Judge Lyman specifically ruled that Abel had adequately alleged that Jones and her associates knowingly accessed her phone and her accounts without her permission. Abel says she provided her passcode only for the limited purpose of transferring her phone number from one device to another. She says Jones retained access to her iCloud even after that limited purpose was complete and used that access to get into her data. Abel alleges this was done without her permission, and that once they had access to her iCloud, they could bypass the normal password protections that would have otherwise blocked them. Taken together with the other allegations in Abel's counterclaim, the judge concluded that this is a plausible case of unauthorized access. And remember, under California law, this is not just a civil matter. Section 502 also has a criminal counterpart. That means the same allegations that are playing out in civil court could also spark interest from California prosecutors if discovery turns up enough proof of intent. And misuse law enforcement could theoretically get involved. The second surviving claim is conversion. Conversion is an old legal doctrine often described as civil theft. It applies when someone wrongfully takes or interferes with another person's property, depriving them of its use. Abel alleged that she was cut off from her phone number, her accounts, her two-factor authentication codes, and all the access she needed for both personal and professional use. She says she spent time, money, and effort just trying to regain control. Judge Lyman agreed that those allegations plausibly showed damages, and therefore the claim of conversion also survives. When you combine these two claims, the picture becomes clearer. Abel is saying Jones wrongfully accessed her phone data unauthorized and then also deprived her accounts and her number. That combination of wrongful act and actual harm makes for a very strong case. Now, why is this such a threat for Blake Lively? Because Abel's central allegation is that the data Stephanie Jones accessed is exactly what ended up in Blake Lively's hands and eventually in a lawsuit against Abel and Baldoni. If Abel can prove that chain of custody from her phone to Jones to Van Zandt to Blake, then it strikes at the very foundation of Blake's entire case. Let us dive deeper into what the judge said about the work phone defense. Stephanie Jones has claimed that it did not matter if she accessed Abel's phone because it was technically a work phone, but Judge Lyman said he would take Abel's allegations as fact at this stage, and Abel alleged that she never consented to that kind of monitoring. She says Jones Works, the PR company, did not have any policies that allowed them to monitor her personal phone, and that she only allowed her personal number to be ported into a work device because she expected she would still have exclusive control over her personal data. That context is important because it undercuts the idea that Jones had any legal right to dig into Abel's iCloud or communications. The judge pointed out that if Abel had known her data would be accessed, she would never have turned the device over at all. So right now, Abel has two strong claims moving forward. Section 502, unauthorized access, and conversion civil theft both allow her to push into discovery, which means emails, text, internal communications between Jones, Van Zandt, and potentially even Blake Lively's legal team could all be exposed, and discovery is often where the real story comes out. Now let's take a closer look at the claims that were dismissed but with leave. To amend, starting with the Stored Communications Act, this law protects electronic communications that are held in storage by providers like iCloud, Gmail, or WhatsApp. The judge said Abel did not plead clearly enough that her data was accessed from that stored environment, as opposed to simply being pulled directly from her phone. To fix this, she would need to provide examples of data that she knows was stored only in the cloud and was still taken, if she can point to a screenshot or a photo that was only in iCloud. Then she could revive that claim. Next, the Wiretap Act. The Wiretap Act requires proof of interception in real time while the communication is in transit. Abel's claim did not show that she only alleged that her communications were accessed after the fact. To fix this claim, she would need to allege that her communications were monitored live, or as they came through iCloud again. If she could provide evidence of that, it could revive the claim. The invasion of privacy claim under California law was also dismissed, but again without prejudice. The judge said it lacked detail about why the intrusion was highly offensive for this. Abel will need to spell out the humiliation, the harm, and the seriousness of her private phone content being exposed. She will need to show that this was not just a technical violation, but a deeply invasive act that struck at her most intimate expectations of privacy. The same goes for her claims of emotional distress. The judge said they were too vague. She needs to provide details about the stress, the sleepless nights, the anxiety, the reputational damage that she suffered because of losing control of her phone and having her private information used against her. And finally, the promissory fraud claim also needs more detail. Abel alleged that she handed over the phone with a promise that was only to port her number and that Jones promised she would get it back, but she needs to specify exactly who made the promise, when they made it, and how she relied on it to her detriment. If she can lay out those details, that claim could also be saved. So what does all of this mean for Stephanie Jones? For Jones, it means she is now facing two very significant claims. A federal lawsuit claims that not only could lead to damages, but could also expose her to criminal liability if prosecutors get interested. Because remember, Section 502 is not just a civil statute, it is also a crime. And the more discovery that comes out, the more risk there is that someone will say this was not just civil misconduct, it was criminal hacking. What does it mean for Blake Lively and Van Zandt? It means that if Abel can prove the chain from her phone to Jones to Van Zandt to Blake, then Blake's entire evidentiary foundation could collapse, because if the data was stolen, then everything that was built on that data is tainted. That includes subpoenas, court filings, even the Doe lawsuit that Van Zandt filed in New York, which Abel claims was a sham designed to launder stolen data into legitimate litigation. And the judge has already said Abel can obtain Van Zandt internal communications and email, so discovery is going to dig right into whether Van Zandt lawyers knew that the data they were working with had been obtained unlawfully. If that comes out, it could mean sanctions, exclusion of evidence, and even liability under Section 502 for anyone who knowingly used or benefited from the unauthorized access that could potentially include Blake Lively herself. This ruling therefore opens a door for Abel not just to push back against Jones, but to potentially add Blake Lively and Van Zandt as defendants if she can show that they knowingly benefited from or assisted in the use of her stolen data. California law would allow her to bring them directly into the case, and the timing is also important. Abel has until October 31st to file her amended complaint. After that, there will almost certainly be another motion to dismiss, but on the claims the judge has already said are properly stated, he is not going to dismiss them again. Those are moving forward no matter what. So where does this leave us? It leaves us with a very precarious situation for Stephanie Jones, and a very risky situation for Blake Lively and her company. If Abel can prove her case, the entire foundation of Blake's lawsuit against Baldoni, Abel, and others could collapse. The evidence could be excluded. The case could be seen as built on stolen material, and the narrative that Blake's team has been pushing could unravel completely. For Jen Abel, this is a big win. It shows the court is taking seriously her allegations that her phone data was stolen and weaponized against her. It gives her the chance to get discovery and potentially prove her chain of custody story, and it strengthens her leverage going into the next stages of this litigation. So what do you think? Are you surprised that Judge Lyman allowed these claims to survive? Do you think Abel will be able to prove the chain from her phone to Jones to Van Zandt to Blake? And how do you think Blake Lively and Ryan Reynolds are going to spin this ruling in the media? Drop your thoughts down below in the comments if you found this breakdown helpful. Make sure to hit the thumbs up button, subscribe if you have not already, and ring the bell so you never miss a video. Thanks for watching, and we will be keeping a very close eye on what comes next in this dramatic legal battle.